Welcome back to the deep dive. Really glad you could join us today. We're tackling something absolutely core to how companies work. The people in charge. We're going deep into company directors. Who are they? What exactly do they do? How do they get the job? How can they lose it? And what about this really serious idea of disqualification? Now, this deep dive draws heavily on some fantastic source material shared for educational purposes by the University of London. We're very grateful they make these resources available. They really help clarify these, let's face it, quite complex legal areas. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka. For everyone out there studying, especially if you've got company law exams looming, listen up. This should really help, and honestly, good luck. Okay, so our mission today, to unpack the key ideas, the crucial laws, those section numbers you need, and the really important court cases about company directors. We want to give you the essential facts and principles so you can really get a handle on this for your studies.
Exactly. The source material lays it out nicely. We'll cover, what a director actually is, that power dynamic between the board and the shareholders, the different types like de facto and shadow directors, how they get appointed, paid, removed, and disqualification. And one thing to always keep in the back of your mind is how different things can look in a small private company versus a big publicly listed one. That contrast is really key to understanding how these rules work in practice.
Right, let's dive straight in then. The absolute basics first. When UK company law talks about a director, who are we actually talking about? What does the law say?
Well, the starting point in terms of who can be one is surprisingly open. There aren't many prior qualifications needed by law, but the law does insist that every company must have directors.
Okay, so it's mandatory.
Yes. For a private company, you need at least one. For a public one, the minimum is two. That's laid out clearly in Section 154 of the Companies Act 2006.
Section 154, got it. One private, two public.
Precisely. And there's a future rule coming in, Section 156A, that says they have to be actual people, natural persons, not another company. And really importantly, there's an age limit. Section 157 of the CA 2006 says you have to be at least 16.
16. Wow.
Yeah, 16. So those core sections to remember right at the start. S154 for the minimum number, and S.157 for that minimum age of 16.
Okay, so legally, the bar seems quite low to get started. But you mentioned the difference between small and large companies. Who tends to actually be a director in practice?
Oh, it's often night and day. In your typical small private setup, the directors are usually the owners, the shareholders. They're directors because they own the business and want to run it.
Makes sense.
But in a big public company, it's usually about expertise. Directors are appointed for their skills, their experience, maybe their contacts. They might get shares later, maybe as part of their pay package, but they weren't usually appointed because they were already big shareholders.
It is interesting, though, that the law doesn't demand specific skills up front.
Yeah.
Seems like quite a leap of faith.
Well, yes, in a way. The law tends to regulate conduct and impose duties once someone is appointed, rather than setting high entry barriers. The consequences come later if things go wrong.
Right. So, okay, they get appointed, they form a board, but then who's really running the show? Is it the board making the management decisions, or is it the owners, the shareholders, in their general meetings? Feels like a potential tug of war.
It definitely has been historically, and the legal balance has shifted quite dramatically. Originally, the general view is that the shareholders in their general meeting were supreme. Directors were treated almost like agents.
I mean, they just had to do what the shareholders told them.
Pretty much. If the shareholders passed an ordinary resolution, just a simple majority vote instructing the board to do something, the board was expected to follow. But that all changed with a really pivotal case. This is one you absolutely have to know. Automatic Self-Cleansing Filter Syndicate Co. Ltd v. Cunningham. It's a mouthful. From 1906, let's say it again. Automatic Self-Cleansing Filter Syndicate Co. Ltd v. Cunningham, 1906.
Automatic self-cleansing filter. V. Cunningham. Okay. What happened there?
In that case, the company's rules as articles of association explicitly gave the power to manage the business to the directors. The shareholders tried to force the directors to sell some company assets by passing an ordinary resolution.
And the court said no.
Exactly. The court held that if the articles give management power to the board, the shareholders cannot just interfere with the board's decisions using an ordinary resolution. The board's authority comes from the articles, the company's constitution, not directly from the shareholders on a day-to-day basis.
So Cunningham really boosted the board's power.
Massively. It established that principle where articles grant management power to the board. Shareholders can't just override specific decisions by ordinary resolution. They'd need to use powers specifically reserved to them, like changing the articles or removing the directors. Remember Cunningham for that principle.
And how does that play out in modern companies? Do standard articles reflect this?
Yes, absolutely. If you look at the standard model articles, which many companies adopt, Regulation 3 gives the general management power squarely to the directors.
So shareholders can't interfere at all under the model articles.
Well, they can, but it's harder. Regulation 4 allows shareholders to give directions to the board, but crucially, it requires a special resolution.
And a special resolution is what exactly? Remind us.
Good point. An ordinary resolution needs just over 50% of votes cast. A special resolution needs a much higher threshold, at least 75% of the votes cast.
Okay. So 75% majority needed to tell the board what to do under Regulation 4. That's a big difference from just needing 50%.
It is. It reinforces the Cunningham idea that directors manage, but provides a mechanism for significant shareholder consensus to intervene.
So the board manages, drawing power from the articles via Cunningham, and shareholders need that high 75% hurdle under Regulation 4 to direct them. But you mentioned shareholders still have residual powers. They're not totally sidelined.
Not at all. They keep some really fundamental powers. The big ones are appointing directors and, as we'll see, removing directors. That's a key check. And there's an interesting exception. If the board becomes completely unable to act, maybe because they're deadlocked in disagreement, the power to manage can actually fall back to the shareholders.
Really? So the shareholders step in?
Yes, out of necessity. That principle comes from a case called Barron v. Potter, 1914. So Barron v. Potter is your authority for management power reverting to shareholders if the board is totally stuck.
Makes sense. Someone has to steer the ship. Now, thinking practically, especially in larger companies, boards don't do everything themselves, do they? There must be delegation.
Oh, huge amounts. You have executive directors, usually employees, who handle the day-to-day operations. The board itself, particularly the non-executives, often focuses more on the bigger picture strategy, oversight, monitoring how the executives are doing.
Right, and getting people onto the board in the first place. How does that happen after the company is set up?
Well, the very first directors are usually just named in the company registration documents. After that, under typical rules like the model articles, there are generally two ways. First, the existing board can usually appoint new directors to fill vacancies or add members. That's in Regulation 17 for private companies, Regulation 20 for public ones in the model articles. Second, and this is vital for shareholder influence, the shareholders themselves can appoint directors by passing an ordinary resolution in a general meeting. Regulations 17 and 20 cover this route too.
So in a small company where maybe one family owns most shares, they can just vote in whoever they want using that ordinary resolution.
Pretty much. They have direct control. And if the board appoints someone they don't like, the majority shareholders can usually remove them fairly easily. We'll get to removal shortly.
So if you're a minority shareholder wanting a say, you might need something specific in the articles.
Exactly. You might need a clause guaranteeing you the right to nominate or appoint a director. In bigger companies, it's often the existing board that identifies and proposes new directors, sort of self-replication, making it harder for shareholders to push their own candidates unless they're very organized.
Okay, let's shift to money. Getting paid. Does being a director automatically mean you get a salary?
Another common misconception. The default legal position, stemming from old trust law ideas, is actually no. Directors aren't automatically entitled to payment just for being directors.
Really? So you could do the job for free?
Legally, yes, unless the company's articles specifically allow for payment or there's a separate contract, a service contract between the director and the company. The classic case for this principle is Re. George Newman & Co., 1895.
Re. George Newman & Co. No automatic right to pay.
That's the one. Now, the model articles do address this. Regulation 18 for private, Regulation 22 for public companies say that directors are entitled to such remuneration as the directors may determine.
Wait, as the directors may determine. So the board sets its own pay.
Yes. Which, as you can imagine, raises eyebrows, especially in big public companies.
That sounds like a potential conflict of interest right there. the whole fat cat pay issue.
Absolutely. It's a huge area of debate. The source material mentions ways companies try to manage this, things like having independent remuneration committees look at pay, disclosing pay details, giving shareholders advisory votes, say, on pay. We'll likely explore those more in Chapter 14 material. But for an individual director, say like Alex, in that Activity 9.2 scenario from the source material joining a small company, accepting pay just relying on the board, which includes Alex, to vote for payment under the articles is risky
Why risky?
because the board could change its mind or future boards might not agree. The safest way by far for any director expecting payment is to have a proper service contract with the company clearly stating their salary and benefits. That contract gives them a solid enforceable right.
Get it in writing.
Yeah.
Sounds like good advice in any situation.
Yeah.
Okay, so we know how they're appointed, how they might get paid.
Yeah.
But what if shareholders are unhappy? Can they just fire a director?
Yes, this is a really critical power for shareholders. It's their ultimate tool for holding the board accountable. The absolute key law here is Section 168, subsection 1 of the Companies Act 2006. Let's lock that in. S.1681 CA 2006.
S.1681, what does it say?
It says a company may remove a director by ordinary resolution before their term of office ends. Simple majority vote. And here are the two really crucial things about S.168. First, it's an ordinary resolution. Second, this power exists notwithstanding anything to the contrary in the company's articles or in any agreement, like a service contract, between the company and the director.
Wow, so the shareholders' power under S.168 basically trumps the articles in the director's contract when it comes to removal.
Yes. The contract can't prevent the removal itself. The articles can't prevent it either, not directly anyway. Ordinary resolution overrides contracts and articles. Those are the key takeaways for S.1681.
That sounds incredibly powerful for shareholders. Can directors fight back at all? Are there obstacles?
Well, they have some procedural rights. Under Section 1692, the director facing removal has the right to speak at the meeting where the vote happens. And under Section 1694, they can insist the company circulates their written arguments against removal to the shareholders beforehand.
Does that make much difference in practice?
Maybe in a large company with lots of shareholders who might be undecided. In a small company, if the majority shareholders want someone out, these rights probably won't change the outcome, realistically. The real obstacle often isn't legal procedure, it's money, cost.
How so?
Because even though S.168 overrides the service contract to allow removal, it doesn't wipe out the director's contractual rights entirely. Section 116.8.5 specifically preserves the director's right to claim compensation or damages if their removal breaches their service contract.
Ah, so you can sack them using S.168, but you might have to pay them out under their contract.
Exactly. And if they had a contract with, say, 3 years left to run, that compensation could be substantial, a big financial hit for the company. That cost is often the biggest deterrent for shareholders thinking about using S.168.
Right, so there's a potential sting in the tail.
There is. And to stop directors giving themselves super long contracts just to make removal too expensive, there's another section, Section 188 of the CA 2006. This requires shareholder approval for any director service contract that's guaranteed to last longer than 2 years. So S.188 tries to limit that compensation risk. And there's another potential cost, especially in smaller companies where directors are often also shareholders.
What's that?
If you remove a director who is also a shareholder, they might be able to bring a claim under Section 994 of the CA 2006. This is about unfair prejudice. In companies that operate a bit like partnerships, quasi-partnerships, removing someone from management might be seen as unfairly damaging their interests as a shareholder.
And the result of a S.994 claim.
It could lead to a court order forcing the other shareholders to buy the removed director's shares, often at a price set by the court, which might be quite high. So using S.168 could trigger an expensive S.994 buyout. That's something we look at more in Chapter 12 material.
Okay, so removal under S.168 is possible, but potentially costly due to contract payouts or maybe S.994. Can directors make removal legally impossible using the articles, despite S.168 saying it overrides them?
You can't just write S.168 doesn't apply. The law won't allow that. But there is a clever way, using voting rights, that was approved by the highest court. This brings us to another absolutely essential case. Bushell v. Faith, 1970. Say it with me. Bushell v. Faith, 1970.
Bushell v. Faith, 1970. Sounds important.
It really is for understanding director entrenchment in private companies. In Bushell v. Faith, the company's articles had a special clause. It said that on a vote to remove a particular director, the shares held by that director would carry extra votes, say 3 votes per share instead of the usual one, but only on that specific removal resolution.
So they got super voting power just for that one type of vote.
Exactly. This meant the director could use their weighted votes to defeat the ordinary resolution required by S.168, even if every other shareholder voted to remove them.
And the court allowed this, even though S.168 says it overrides the articles.
Yes, the House of Lords did. Their reasoning was that S.168 dictates the type of resolution needed, ordinary, but doesn't dictate how voting rights attached to shares are calculated. If the articles validly give certain shares extra votes on specific issues, that's generally allowed as part of shareholder agreements on share rights.
So Bushel v. Faith essentially creates a loophole to S.168 using weighted voting clauses.
That's a good way to put it. Bushel v. Faith allows directors in private companies to entrench themselves against removal by ordinary resolution if the articles are drafted correctly. It's worth noting, though, that for public companies listed on the London Stock Exchange, these types of weighted voting clauses are generally prohibited by the listing rules now. But for private companies, Bushel v. Faith remains key law.
Fascinating stuff. Okay, let's broaden out again. We've talked about directors, but are there different legal categories or types we need to distinguish?
Yes, definitely. And understanding these categories is crucial because the law, especially regarding duties and liabilities, can apply differently. These categories aren't always mutually exclusive either. The most obvious type is the de jure director. Let's repeat that. De jure director. This is just the formally, validly appointed director. Their name is on the official register, appointed according to the rules. Straightforward.
Okay, the official director. What else?
Then we have people who act like directors but haven't been formally appointed. The first category here is the de facto director. Repeat that. De facto director.
De facto, meaning in fact.
Exactly. The Companies Act definition of director in Section 250 includes not just the de jure ones, but also any person occupying the position of director by whatever name called. A de facto director is someone who, in reality, is doing the job of a director, even without the formal title.
How do you tell if someone's crossed that line into being a de facto director? What do courts look at?
They look at the substance, not the label. It's about what the person actually does. Key case law gives us pointers. It's about their function, not their job title. Read Gemma Ltd. Are they considered part of the company's corporate governing structure? That phrase comes from Secretary of State V. Chichel.
Part of the governing structure. Like attending board meetings.
Often, yes. Participating in board decisions as an equal with the de jure directors is a strong indicator, as highlighted in Secretary of State V. Hollier. In less formal companies, maybe without regular board meetings, the question might be whether they were acting as one of the main decision makers, part of the nerve center, like in Umbrella Care Ltd v. NISA.
So Chichel, Hollier, Umbrella Care. These cases help define it by looking at their actual role and influence.
Precisely. And the key legal consequence. Because Section 250 includes them in the definition of director, most of the duties and rules in the Companies Act that apply to directors, like the main general duties in Sections 171 to 177, automatically apply to de facto directors too. They can't escape liability just because they weren't formally appointed.
So the law catches them. What's the other main category of unofficial director?
That's the shadow director. Let's repeat. Shadow director. This concept targets those who control the company from behind the scenes, the puppet masters.
Pulling the strings.
That's the idea. The definition found in Section 251 of the CA 2006 and also in the Disqualification Act is a person in accordance with whose directions or instructions the directors are accustomed to act.
Accustomed to act. So it has to be a pattern.
Yes, absolutely. It's not enough if the board follows their advice once or twice. There must be a pattern where the board habitually follows their instructions, often without exercising its own independent judgment. That was emphasized in Rehydrodam, Corby Ltd.
What about, say, a dominant shareholder or a bank? Could they become shadow directors?
Potentially, yes, if their influence goes beyond merely giving advice or protecting their own interests. Professional advisors like lawyers or accountants are generally excluded unless their actions cross the line to effectively controlling the board's decisions. Retasbian Ltd, number 3. Also, the control usually needs to extend to the whole board, or at least a governing majority of it, not just influencing one director. Cases like Relowline Electric Motors Ltd. And Unisoft Group Ltd, number 2, establish that.
Okay, so pattern is control, Hydrodam, over the whole board or a majority, Lowline Unisoft, and watch out for advisors crossing the line, Tasbian. And legally, how are shadow directors treated compared to de facto ones?
This is a really important distinction. Unlike de facto directors, shadow directors are not generally included in that main definition of director in S.250.
So the general rules don't automatically apply.
Correct. A specific law only applies to a shadow director if it explicitly says so. A key example is wrongful trading liability under Section 214(7) of the Insolvency Act, 1986. That section specifically includes shadow directors.
What about those main director duties? Sections 171, 177, do they apply?
That's a bit more nuanced. Section 170 of the CA 2006 does say the general duties apply to shadow directors, but only where and to the extent that they are capable of so applying. Meaning it depends on the nature of the instructions the shadow director gives. If they instruct the board to breach a duty, then the corresponding duty might apply to the shadow director in that context. The case Standish v. Royal Bank of Scotland Plagalac confirms they can apply, but it's context dependent.
Okay, that's clear. De jure, formal, de facto, acting as generally treated as director, shadow, controlling from behind, only caught by specific rules or contextually by duties. Any other common ways directors are described?
Yes, the very common practical distinction between executive and non-executive directors.
Exec and non-execs.
Exactly. Executive directors are usually employees, involved in the day-to-day running of the business. Non-executives are typically part-time, attend board meetings, and are there to provide independent oversight and challenge. Legally, the Companies Act doesn't generally distinguish their core duties. A director is a director. But corporate governance codes, especially for listed companies, place huge emphasis on the role and independence of non-execs.
That makes sense. Okay, that covers the types really well. Let's move to the final and quite serious topic, disqualification. This isn't just about losing your job at one company, right? This is much bigger.
Much bigger. This is about protecting the public by preventing individuals deemed unsuitable from being involved in managing any company for a period. The main law here is the Company Directors Disqualification Act 1986. Let's call it the CDDA 1986.
The CDDA 1986. And what does a disqualification order actually do?
Its effect, under Section 1.1 of the CDDA 1986, is broad. For the specified period, the person cannot be a director of a company. They also can't act as a liquidator, administrator, or receiver. And crucially, they can't be concerned or take part directly or indirectly in the promotion, formation, or management of a company without court permission.
So you can't just switch titles and carry on managing behind the scenes, be a consultant or something.
Absolutely not. The law is wise to that. Case law confirms concerned or take part in management covers things like acting as a management consultant if you're essentially directing the company, R.V. Campbell, or being involved in setting up a new venture, Recon and Quest. It's a comprehensive ban on involvement.
Okay, it's serious. What are the grounds? Why would someone get disqualified?
The CDDA 1986 has several grounds, things like being convicted of serious offenses related to companies, persistent failure to file documents, fraudulent trading. But the most common ground, by a huge margin, responsible for thousands of disqualifications each year, is unfitness. That's found in Section 6 of the CDDA 1986.
Section 6, CDDA 1986. Unfitness. That's the main one to know.
Definitely. The CA6 test has two conditions. First, the person must have been a director of a company that has become insolvent. Second, the court needs to be satisfied that their conduct, as a director of that company, or others, makes them unfit to be concerned in the management of a company.
Unfit to manage any company, not just the one that failed.
Yes, exactly. It's about general competence and probity. Cases like Repolypec International, No. 2, and Regrain Building Services, Ltd. confirmed it's a question of fitness to be involved in managing companies generally. The disqualification period under S.6 must be between 2 and 15 years.
So insolvency plus unfitness. How do courts decide what counts as unfit? What sort of behavior are we talking about?
Well, Section 9 of the CDDA 1986 points the courts towards matters listed in Schedule 1 of the Act. These include things like breach of duty, misusing company money, responsibility for the company's failure, not keeping proper accounts, trading wrongfully, a range of misconduct.
But here's a key question. Does it have to be dishonest behavior? Or can simple incompetence, just being bad at the job, be enough to be found unfit?
That's a really important point of debate. Courts are generally reluctant to disqualify directors just for making honest mistakes or bad commercial judgments.
Yeah.
Running a business is risky after all. However, incompetence can be grounds for unfitness if it's severe enough. The landmark case setting the standard here is Re-Lowline Electric Motors Ltd. 1988. Let's repeat that case. Re-Lowline Electric Motors Ltd. 1988.
Relow line. What did it say about incompetence?
The judge stated that while ordinary commercial misjudgment is not enough, conduct falling below accepted standards of probity, like dishonesty, clearly is. But importantly, he added that conduct showing gross negligence or total incompetence would also be enough to justify a finding of unfitness under S.6.
So not just a mistake, but gross negligence or total incompetence. That's a high bar, but it means incompetence can be enough.
Yes. If the director's failures are really egregious, demonstrating a complete lack of understanding or care, that Ray-Lone standard might be met. Other cases, like Dawson Print Group Ltd., followed this line. So, incompetence can lead to disqualification if it's sufficiently serious. It's also worth mentioning disqualification undertakings. Introduced by the Insolvency Act 2000, these allow a director to voluntarily agree to be disqualified for a certain period, avoiding court proceedings. It has the same effect as a court order.
A sort of plea bargain for disqualification.
In a way, yes. And there's another relatively recent development, compensation orders. These were added by Section 15A of the CDDA 1986. Let's flag that. S15A CDBA 1986, compensation orders.
Compensation. So the disqualified director might have to pay money.
Yes. If a person is disqualified and their conduct which led to the disqualification caused loss to creditors of an insolvent company they directed, S15A3B, the court can order them to pay compensation.
Where does the money go?
It goes towards the assets of the insolvent company, so it effectively benefits the creditors who lost out. It's a way to make directors personally liable for the financial consequences of their misconduct that led to disqualification. We're starting to see cases on this now, like Re-Noble Vintners Ltd. 2019 and Re-Pure Zanzibar Ltd. 2023. These cases are exploring how courts decide how much compensation should be paid under S1FA.
So it adds another layer of potential personal liability alongside things like wrongful trading.
Exactly. Wrongful trading S214 Insolvency Act 1986 is typically brought by a liquidator. These S15A compensation proceedings are brought by the state, the Secretary of State, usually following a disqualification. It's still relatively new, but potentially very significant.
Okay, that's a lot on disqualification.
Yeah.
Just to be absolutely sure we got the distinction clear for studying removal under S168 versus disqualification under the CDDA, what's the absolute core difference?
Okay, core difference. Removal under S.168 is an internal company mechanism. It's triggered by shareholders. Ordinary resolution. It doesn't require any finding of fault or misconduct. Its effect is limited to removing the director from their position in that specific company.
Internal, shareholder-driven, no fault needed, specific company.
Got it.
And disqualification.
Disqualification under the CDDA 1986, especially as .6 unfitness, is a public law remedy. It requires specific grounds, usually serious misconduct or incompetence linked to insolvency. Its purpose is public protection. Its effect is general prohibiting the person from being involved in the management of any company for the duration of the order.
Public law requires fault and fitness, protects the public, bans involvement in any company. Perfect. That's a really clear distinction. Wow. Okay, we have covered a huge amount of ground. We started with who directors are, S1554, S1577, that power balance with shareholders. Remembering Cunningham gave boards management power unless shareholders use a special resolution, Red 4, or the board's deadlocked, Baron v. Potter.
Yeah.
Then removal via S168, that powerful ordinary resolution, but with costs like contract payouts, S1685, limited by S188, or maybe S.994 claims, and the Bushel v. Faith-weighted voting escape route.
Then the categories. De jure, de facto, acting as if, caught by S.250, tests from UoL, Hollier, Umbrella Care, and Shadow Directors, controlling S251 definition, tests in Hydrodam, Tasbean, Lowline, Unisoft, and how rules apply differently. And finally, disqualification via the CDDA 1986, focusing on that main S.6 unfitness ground, the crucial Re-Lowline standard for incompetence, and the newer S15A compensation orders, with early cases like Re-Noble Vintners and Re-Pure Zanzibar.
That's an excellent recap. So for everyone listening and studying, the strategy seems clear. Know the definitions, nail down those key section numbers, S154, 157, 168, 169, 188, 250, 251 of the Companies Act, the core CDDA sections like 6 and 15A, and really get to grips with the key cases, know the name and the principle or test it stands for.
Absolutely. Practice applying those principles. Think about how they work differently in small versus large companies. Understand why the law distinguishes between de facto and shadow directors. It's about applying those legal tools, the sections, and cases accurately.
This has been incredibly helpful. Thank you. So a final thought for you, the listener. to mull over as you continue your studies. Think about everything we've discussed, the low bar for becoming a director, the Cunningham power balance, the duties removal, disqualification under the CDDA, the RIN-low line standard. Does UK law get the balance right? Does it sufficiently empower directors to run businesses effectively while also adequately protecting shareholders, creditors, and the public from incompetence or abuse? Or does the balance need shifting? Something to think about. Thank you again for joining us on this deep dive into company directors. We really hope it's clarified things and helps you move forward in your studies with confidence. All the very best, and good luck with that exam.